Before I hand over, I just wanted to very briefly welcome you all in the name of the New Zealand Centre of International Economic Law. We are incredibly grateful that we could team up with the New Zealand Initiative. We have not done this before, and it's nice as a Centre for Economic Law, International Economic Law, to actually kind of do events with the business community, and I think that is fantastic. And in that sense, I would like to actually get Eric Hampton from the New Zealand Initiative now to actually lead this debate on the Bilateral Arbitration Treaty.
Thank you. All right, yeah, thanks everyone for coming. I'm head of research with the New Zealand Initiative, and I'm very happy to be able to introduce Gary Bourne here today. He's the chair of international arbitration and international litigation practices at Goldman Cutler, Pickering, Hale, and Dorr. He's taught on international arbitration and litigation at the world's top universities, drawing on a lifetime's practical experience in the field, both as arbitrator and as counsel. He's written the book on international commercial arbitration. His work in the area has been cited hundreds of times in Google Scholar. Impressive record both on the academic side and on the practical side. We're very lucky to have him here today. International arbitration and mediation is a really interesting area. I wish I had time to look at it more. It's not a new field. Well, bits of it that I know from economic history is some coming from the work of Avner Greif. He describes there how the law merchants, the Maghreb traders, back in the 11th century, they focused on trade around the Mediterranean. You had fairly free trade arrangements, but you had problems in contract enforcement and arbitration. They had a code of conduct and an arbitration facility for preventing disputes and arbitrating them back in the 11th century. Reputation there helped to work to enforce judgments and prevent disputes. No trader could really afford to go against the law merchant's judgments because they knew that they'd be shut out of transactions afterwards. States didn't enforce the contract. Reputation through arbitration and the contracting nexus of the Maghrebis did. Today, Gary's going to be talking to us about problems in international arbitration and negotiation, focusing on bilateral treaties that might facilitate things for cases where firms haven't specified adequate arbitration facilities, and I'm really looking forward to hearing all about it. Thank you.
Thank you so much, Eric, and thanks also to the New Zealand Initiative as well as the New Zealand Center for I've managed to miss that name every time I've given this speech, the New Zealand Center of International Economic Law, for the invitation to be here today, and thank all of you for taking time out of what I'm sure are busy schedules to listen to my remarks. The title, such as it is, of my remarks today is Bits, Bats, and Buts, Reflections on International Commercial Dispute Resolution. And I think with a title like that, I also owe you an explanation of the title. First, the first word of the title, bits, refers to a creature already in existence called bilateral investment treaties. And the first third of my talk will discuss those treaties, bilateral investment treaties, or BITs. The second of the three parts of my talk concerns BATs, bilateral arbitration treaties. These aren't, in contrast to BITs, creatures that already exist, but instead ones that the basic thesis of my comments is should exist. We ought to have, just as we have BITs, indeed for even more reasons than we have BITs, to have BATs. And most of my comments will be directed to fortifying that premise, that conclusion. In the final part of my remarks, buts are all the reasons that might occur to you, might occur to others, that the proposal for bilateral arbitration treaties, the proposal for BATs, isn't well considered, isn't something we should in fact pursue, is something which on sober reflection we ought to run away from. But at the end of my remarks, I hope we'll see that the various buts that I outline, the various reasons not to pursue bilateral arbitration treaties, are in fact not, on sober reflection, real obstacles, and that in fact bilateral arbitration treaties are just the thing that international commerce just the thing that New Zealand business, just the thing that the New Zealand initiative needs. And then finally, I'll try and say a few words just briefly about the New Zealand situation in particular. All of these comments also, given that we're here in an academic institution, indeed one of the world's leading legal academic institutions, are meant in the spirit of education. Even if at the end of the day you disagree with me, even if at the end of the day you conclude that the buts outweigh the bat, the arguments for the bat, at least the process of exploring the Bilateral Arbitration Treaty, exploring the current default regime that we have for international commercial dispute resolution are things that would lead us to an alternative solution, a better solution than what we currently have. But with that introduction, let me start with bilateral investment treaties BITs. Currently today, there are some 3,000 bilateral investment treaties in force. These bilateral investment treaties have occasioned a fair amount of controversy. They still do, for reasons that I'll mention in a moment. But they nonetheless currently provide a very broad framework, a very broad set of provisions that are fundamental to many aspects of international investment. And these bilateral investment treaties entered into between two states, let us say hypothetically, New Zealand and Saudi Arabia, do basically two things. These treaties guarantee on the one hand to investors of the two contracting states certain substantive international law protections. Broadly speaking, those substantive international law protections are fundamental human rights, protections against things like expropriation of property without fair compensation, guarantees of fair and equitable treatment, justice in both national courts, but other national governmental administrative proceedings. Those substantive fundamental rights are intended to ensure that investors from the two states are treated fairly in the respective treaty parties, in my example, New Zealand and Saudi Arabia. Together with those substantive legal protections, though, bilateral investment treaties do a second thing. And the second thing that they do is provide a dispute resolution mechanism, a means of enforcing, giving effect to those substantive international law protections. One could have imagined a variety of different dispute resolution mechanisms being adopted for these 3,000 bilateral investment treaties. And I should emphasize, these 3,000 bilateral investment treaties bind virtually all states in contemporary world affairs. Parties from states from every part of the world, Latin America, Asia, Europe, North America, Africa, are party to BITs, to bilateral investment treaties. States began entering into bilateral investment treaties some 60 years ago in the 1950s and have continued with ever-increasing frequency over the past decades to conclude these treaties. And as they've done so, they gave thought to what sort of dispute resolution mechanism ought to be included in the treaty in order to ensure that the substantive legal protections for investors and for host states were given full effect. They thought about referring these disputes to an existing international court. No court seemed satisfactory. The International Court of Justice had both a focus on state-to-state disputes, not investor-state disputes. It also had a caseload and a composition that made it appear, I think with good reason, not well suited to resolving these sorts of business and investment disputes. Thought was given to creating a new international court, a so-called global investment court. And again, the difficulties in identifying a composition, creating a standing permanent court that would be well suited not just to New Zealand, Saudi Arabia disputes, but to Peruvian and Chilean disputes or German-Dutch disputes, was thought to be ultimately, and again I think with good reason, insuperably difficult. And so what was decided at the end of the day almost uniformly across these 3,000 treaties, was to provide a right of international arbitration, access to dispute resolution by international arbitration for disputes arising under the substantive international law protections in BITs. And in particular, in doing this, the contracting states to those 3,000 bilateral investment treaties piggybacked, if I can put it that way, on the long history of international commercial arbitration that Eric referred to before. In fact, international commercial arbitration goes back not just to the 11th century AD, but almost to the 11th century BC. There's early records, not quite that old, from what's now Kirkuk in Kurdistan in northern Iraq, describing in cuneiform tablet form commercial arbitrations between local traders and local landowners. Arbitration was used then in antiquity and through the Middle Ages to resolve a whole host of international commercial disputes. Businessmen drawing most comfort from a variety of factors that international arbitration promises, in contrast to other forms of dispute resolution like national court proceedings. It was thought by businesses then, whether then is antiquity, the Middle Ages, or this century, that arbitration enabled parties to choose their arbitrators, choosing women and men who would be expert, to design procedures that would be perfectly tailored to individual disputes, producing expeditious and efficient dispute resolution, choosing arbitrators not from one party or the other party's home jurisdiction, but instead who were as between those two parties neutral, not a Saudi decision maker in a case between New Zealand and Saudi parties, or a New Zealand decision maker for that matter, but instead someone neutral, whether they're Singaporean, English, US, or something else. And finally, creating a mechanism to give effect not just through reputation, as was the case in the 11th century, to enforce these arbitral awards, but also through a legal mechanism. And in particular, jumping just almost to the present, in 1958, 150 countries today signed up to something that was called the New York Convention, the so-called United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. That convention does two things. It guarantees that contracting states will recognize international arbitration agreements and give them effect, referring disputes out of national courts into the arbitrations the parties have agreed. And then secondly, recognize and enforce international arbitral awards, the decisions of those arbitral tribunals constituted pursuant to international arbitration agreements. And in so doing, the New York Convention, to which, as I say today, 150 contracting states around the world are party, ensures that arbitration agreements are respected on the one hand, and that arbitral awards are given full force and effect, that they are enforced just like national court judgments, and indeed much better than national court judgments, because there's no equivalent. There's no global equivalent to the New York Convention for national court judgments. And so one of the reasons that one has seen, not just from 11th century BC or AD, not just from the Middle Ages, not just from the 1920s, but today, and in particular the last 2 or 3 decades, a dramatic increase in the use of international commercial arbitrations has been its enforceability. Arbitral awards are more enforceable than national court judgments. When the arbitrators resolve the parties' business dispute, they do so finally with binding and enforceable effect in a way that no national court judgment can do. They do so in an expert manner because they, the arbitrators, are chosen by the parties who know their dispute best, better than anyone else, who it is that can resolve that dispute most expertly in accordance with the parties' business expectations. They do so efficiently because the procedures are tailored, not one size fits all taken off a shelf, but tailored to specific disputes. And finally, perhaps most importantly, they do so independently and neutrally, not in one party's home courts, not in one party's home jurisdiction, but instead in a neutral, internationally neutral forum, guaranteeing application of the rule of law. And for all those reasons, when the parties to 3,000 bilateral investment treaties came to decide how should we give effect to these substantive international law protections that we've guaranteed. How should we give effect to those protections? They chose international arbitration. That concludes, in a sense, the historical part of my remarks, and also the first of the three parts that I wanted to address. In that process, one thing that happened was that investment arbitration, bilateral investment treaties, as I've said, learned from, transferred technology from international commercial arbitration. And the thesis of the second of the three parts of my comments is that the reverse process can also happen. Just as investment arbitration learned from commercial arbitration, so international commercial dispute resolution, international commercial arbitration, can learn from investment arbitration. And in particular, the thesis of this discussion is that just as we have bilateral investment treaties, we ought to have bilateral arbitration treaties. And put very simply, a bilateral arbitration treaty would provide that, absent contrary agreement, and I'll come back to that important qualification, absent contrary agreement, the default mechanism for resolving business disputes, international commercial disputes between companies, would be international arbitration, rather than the existing default means of dispute resolution that we already use. Put concretely, if New Zealand and Saudi Arabia were to enter into a bilateral arbitration treaty, either as a standalone treaty or as part of some larger free trade agreement, then business disputes between Saudi and New Zealand companies would, instead of being resolved in Saudi or New Zealand courts, be referred to arbitration in accordance with the terms of the GATT, save where the parties had or in the future would agree to the contrary. The bilateral arbitration treaty would set out the specificities of the arbitration mechanism that would be used to resolve those disputes. One could adopt a variety of different procedural approaches to that dispute resolution mechanism. The easiest, and one that is outlined in or incorporated in a draft model bilateral arbitration treaty that I and others have drafted, is for the arbitration to be conducted in accordance with the UNCITRAL arbitration rules, the United Nations Commission on International Trade Law arbitration rules, globally recognized. The drafting was conducted by countries from around the world, all legal cultures, all geographic regions, and widely used every day in international commercial arbitration, international commercial dispute resolution. Those rules would provide the basis for an arbitration between the Saudi and the New Zealand parties that I've referred to. Once that arbitration was concluded, it would produce an arbitral award, just like international commercial arbitrations do every day. And that award then would be, pursuant to the terms of the bilateral arbitration treaty, subject to recognition and enforcement in the two contracting states, Saudi Arabia and New Zealand, subject to the same rules of the New York Convention, the same safeguards for basic procedural fairness, public policy, and the like that the New York Convention provides. Third states, if you will, other countries would be encouraged by the terms of the BAT and perhaps more to recognize the awards on the same basis. And the object of this, one might ask, why do we need this? What is the purpose of a bilateral arbitration treaty? The purpose of the bilateral arbitration treaty is precisely the same purpose as that of the New York Convention, precisely the same purpose of the ICSID Convention and the 3,000 bilateral investment treaties that deal with investment arbitration. The purpose of the New York Convention was to encourage trade by providing a mechanism for resolving international commercial disputes in the most expert, efficient, neutral, and enforceable manner possible. International commercial disputes inhibit trade. They create inevitably uncertainties, risks that don't exist in domestic affairs, where you have a court that can issue judgments familiar to both parties, readily enforceable, no jurisdictional disputes, ready enforcement of the judgment. That is not the case in international commerce. The New York Convention, the 150 contracting states to the convention concluded that it was important in order to facilitate international trade to provide a dispute resolution mechanism that will guarantee that international disputes are resolved just as efficiently, hopefully more efficiently, than national domestic disputes. That's what the New York Convention does. It's also precisely what a bilateral arbitration treaty would do. Now, the New York Convention applies when the parties have entered into a traditional contractual arbitration agreement. It is applicable when the parties have agreed to arbitrate by including a so-called arbitration clause in their underlying commercial contract. The BAT applies when that hasn't happened. As I've said, the BAT is a default mechanism. If the parties want to agree to something different, they're free to agree to something different. And if they do that, the BAT won't apply. When they have done that, when they've agreed to arbitration, the New York Convention will apply. But where they fail to do so, where they don't pay the attention that so often unfortunately occurs in international affairs to future dispute resolution, the BAT provides a default mechanism for resolving those commercial disputes in just the expert, efficient, neutral, and enforceable manner that the New York Convention presently guarantees. And for all the same reasons that states wish to guarantee free trade, guarantee cross-border commerce for the good of us all, for the good of the states' tax revenues, so states ought also to wish to provide a better default mechanism for international commercial dispute resolution when the parties haven't contractually provided for this. The state already provides a default mechanism for international commercial dispute resolution. The question is it the right one? Can't we provide a better one? And my thesis today is that yes, we can. And that thing, the better thing we can do, is a bilateral arbitration treaty. So that finishes with part 2 of my 3 parts and brings us to the buts. What are the reasons that, although it might superficially appear interesting, although it might have some attractions, what are the reasons that a bilateral arbitration treaty is in fact not a satisfactory improvement on our current default regime? The first of the buts is, well, I don't really understand how this could in practice work. Arbitration agreements are negotiated on a case-by-case basis by parties. They sometimes include the seat of the arbitration. They specify how you choose the arbitrators. They choose the substantive law. If parties want, they negotiate fairly complex procedural timetables or other rules governing the arbitration. The BAT, as you've described it, doesn't do that. It doesn't do anything but incorporate the UNCITRAL rules. Isn't that too uncertain? You can't really have an arbitration, or at least a satisfactory arbitration, just based on the skeletal framework that this BAT envisages. That but is understandable, but it's wrong. It's wrong because the vast majority of international commercial arbitration agreements used every day in commerce, used every day in resolving international commercial disputes, are no more detailed than the bilateral arbitration treaty would be. The bilateral arbitration treaty, just like many arbitration clauses, incorporates, as I've mentioned, the UNCITRAL arbitration rules. Those rules, just as they become part of the parties' commercial arbitration agreement, would become part of the legal rules provided by the BAT, pursuant to which the parties' dispute is resolved. And all of the things that I mentioned as uncertainties that might be difficult to deal with in an arbitration are in fact dealt with quite explicitly and quite satisfactorily by the UNCITRAL arbitration rules. Those rules provide mechanisms for choosing arbitrators, for challenging arbitrators if they lack the requisite independence and impartiality, and replacing them, for choosing the arbitral seat, for choosing the language of the arbitration, for choosing the law applicable in the arbitration, the substantive law. And therefore, just as every day Commercial arbitrations are conducted pursuant to arbitration agreements and say no more, literally no more, and sometimes less than all disputes arising out of this contract shall be finally resolved by arbitration pursuant to the UNCITRAL arbitration rules. Exactly the same thing, exactly the same successful arbitrations could be conducted pursuant to the Bilateral Arbitration Treaty. The risk of procedural uncertainty is a false risk, a mirage, not one that really exists. Okay? But there are other buts, other important buts. What about consumers, families, employment disputes, the sort of policy-laden, regulatorily sensitive disputes that states refuse to allow parties to arbitrate? Isn't it unsatisfactory, isn't it entirely unsatisfactory to require consumers or employees to go off and arbitrate their disputes? And the answer to that, Bud, is yes, it is. In many states, that is precisely the conclusion, but the BAT doesn't in any way run counter to that premise. The BAT, as I outlined, applies to, and only to, international commercial disputes between businesses, and in particular between companies. It doesn't apply to consumers or consumer disputes. It doesn't apply to labor disputes between employees and employers. The New York Convention contains in it a broad catch-all exclusion from matters that are subject to arbitration, so-called non-arbitrable disputes, disputes not capable of settlement by arbitration. In some countries that includes competition law disputes, bankruptcy disputes, criminal law matters. And exactly the same exclusion would apply under the Bilateral Arbitration Treaty. The two treaty partners, Saudi Arabia and New Zealand in my example, would be free to negotiate more detailed terms of those exclusions should they be minded to do so. But the focus of the Bilateral Arbitration Treaty, just like the focus of arbitration in the 11th century, is on business-to-business disputes involving commercial contractual matters. It doesn't trench at all upon a state's regulatory authority, rightful regulatory authority over employees, consumers, bankruptcy, and those sorts of things. Okay? But number 3, isn't arbitration founded, isn't all of private international law founded on the principle of party autonomy? Doesn't the Bilateral Arbitration Treaty limit the parties' autonomy to decide how their dispute should be resolved? The answer to that is, were it a legitimate objection, was it in fact true that the Bilateral Arbitration Treaty trenched on parties' autonomy, that would be a serious problem. But it doesn't. The Bilateral Arbitration Treaty leaves entirely untouched the parties' autonomy. Parties are free under the Bilateral Arbitration Treaty, which only provides a default solution. Parties are free to, number 1, opt out of the treaty entirely. Parties are free, just as they're free under the Vienna Convention on the International Sale of Goods, to opt out of its substantive international rules for contract law, to opt out of the BAT, simply by saying that's what they do, should they be minded to do so. Number 2, parties are free to agree to an alternative forum, for example, New Zealand, or if they were minded to do so, Saudi courts. The BAT would in no way limit the parties' freedom to contract into a particular national court regime. And 3, parties would be free to agree, as sometimes they do, not always, but sometimes they do, frequently they do, to a different form of arbitration. Arbitration under, for example, the Singapore International Arbitral Center's arbitration rules, the London Court of International arbitration rules, Australian rules, what have you. The parties' contractual freedom to choose a form of dispute resolution would be entirely unaffected. And therefore, the treaty, the BAT, in no way changes or alters the parties' autonomy. It is nothing more than a default solution. It's not a mandatory default solution. It's a default solution that the parties remain free to contract out of. Okay, you're starting to get traction with me. But number 4, perhaps the BAT doesn't trench upon parties' autonomy, but isn't consent the foundation for arbitration? Aren't these traders back in the 11th century, aren't parties under the New York Convention enabled to arbitrate only because that's what they've agreed to? And by providing arbitration as the default mechanism, doesn't the Bilateral Arbitration Treaty violate that basic requirement for consent? And the answer to that but is yes, but. Yes, the Bilateral Arbitration Treaty does provide for arbitration without the form of consent that we see in a negotiated commercial contract. But that doesn't matter. And it doesn't matter for several reasons. The first of those reasons is that in fact, consent in the context of arbitration comes in a variety of different shades. One of the shades is the heavily negotiated arbitration agreement that I've posited as the kind of ideal model, Platonic version. But there are many other forms of arbitration agreement, including, as we've heard, back in the 11th century, where traders, simply by virtue of belonging to a trade association or engaging in a particular kind of commerce, opted into or accepted a default rule of arbitration to resolve their disputes. And indeed, even today, in some trade associations, in some other associations, arbitration is a mechanism that is used by anyone who becomes part of the association. And there are other forms of consent. For example, and that's one of the reasons I spent so much time with it, under the Bilateral Investment Treaty Regime, where arbitration is in fact legislatively provided by the terms of the BIT itself. One can attempt to create a notion of a standing offer to arbitrate under the Bilateral Investment Treaty that is accepted in traditional contract terms by the investor, but that's all a bit forced. In fact, the Bilateral Investment Treaty itself creates the arbitration mechanism out of whole legislative cloth and provides it to the parties, not because they've negotiated and agreed to it, but instead because it is the best available means for dispute resolution. And so consent comes in a variety of different forms in international affairs. And although the Bilateral Arbitration Treaty certainly does provide a different form of consent, it does provide a form of constructive consent that is not that different than other forms of consent we already recognize. But secondly, and perhaps more importantly, even if one entirely ignores the notion of constructive consent, companies, businesses informed about the existence of a bilateral arbitration treaty through a campaign of publicity from the government, through public notice of the bilateral arbitration treaty, through the council of lawyers and the like, who choose not to contract out of the bat, in effect contract into it. Even if one ignores that notion of constructive consent, it really doesn't matter that the international arbitration mechanism provided by the BAT lacks consent, at least consent in the traditional sense. It doesn't matter because at the end of the day, what the BAT is doing is exactly the same thing that national law, and in some cases treaties, currently does. Namely, providing a default mechanism for the resolution of international commercial disputes. We currently do provide a default mechanism. That default mechanism, in the case of New Zealand and Saudi Arabia, going back to my hypothetical, is that each party is free to sue in its respective national courts. The New Zealand party is free to sue in New Zealand. The Saudi party in Saudi Arabia. And parties not infrequently do. In fact, I say not infrequently because in a substantial number of cases, parties conclude that this whole process of parallel litigations in two national courts isn't worth the candle. They don't want to spend money to resolve their dispute because it is so uncertain, in some cases so unfair and or corrupt, and so unenforceable that it's not even worth trying to pursue your rights. And at the end of the day, even if you have pursued your rights through that parallel mechanism in national courts, you get a judgment that isn't enforceable in the only place it really matters, namely your counterparty's home jurisdiction. And so the basic premise of the Bilateral Arbitration Treaty is one can provide a better default mechanism than already exists. And that is what the BAT is doing, with or without traditional forms of consent. And if parties are not happy with it, they are free to contract out of it. In fact, in the vast majority of cases, they would be happy with it and would continue under it because, and we know that, they already agree to international commercial arbitration in a substantial number of cases. Okay, it's getting more traction. What about butt number 5? Butt number 5 isn't access to courts, isn't a New Zealander's right to go to New Zealand courts, a Saudi business's right to go to Saudi courts, fundamental? Isn't it a right of a civil right, public access to public courts, that we ought not to infringe? And again, the answer to that is yes, but. The answer is yes. Access to justice is fundamentally important. Access to justice is one of the most fundamental and core values that any civilized society shares and provides. But in the international context, we're not talking about access to one nation's courts. We're necessarily talking about access to two nations' courts. And in my example, again, we're talking about access on the one hand to New Zealand courts and in the other to Saudi Arabian courts. And we're talking about both courts, given the state of international law, being unable to render judgments that are enforceable and that therefore finally resolve the party's dispute. There may be occasional cases where a party can enforce the judgment in its own home courts, but in a very substantial number of international cases, that's not so. And therefore, the existing means for dispute resolution fails to provide some of the most important criteria, some of the most important things that a system of justice is meant to provide. Firstly, unlike in the domestic context, it's not at all certain where you can sue. Can you obtain jurisdiction in New Zealand courts over a Saudi party and vice versa? If you do, you need to pay two sets of lawyers in New Zealand and Saudi Arabia to pursue the same claim, ultimately to obtain, all too often, two sets of conflicting judgments, neither of which is enforceable. And at the end of the day, that's not access to justice. That's a denial of justice. It doesn't provide a fair and honest means of resolving, finally, the party's dispute. And if what one really wants is access to justice, the Bilateral Arbitration Treaty provides that. It provides it by allowing for both the New Zealand party in this case and the Saudi party not decision making on one party's home turf in front of a tribunal that may not be experienced in commercial matters and may not, one can think of examples, be neutral as between the parties, and that is not able to finally resolve the party's dispute. That's not justice, and instead what the Bilateral Arbitration Treaty offers is access to justice. And so what we're left with at the end of the day then is one final but. And that but is fear of the unknown. A BAT has not been previously entered into. There have been things that are actually fairly close to bilateral arbitration treaties, starting by way of analogy with bilateral investment treaties, looking also to the Vienna Convention, but it's a new creature. Well, the New York Convention was a new creature in 1958, and the ICSID Convention a new creature in 1965, and the bilateral investment treaties, all 3,000 of them were new creatures when they were thought of. All of those new creatures have grown up and flourished very well. The only real but that remains in the way of the BAT is fear of the unknown, and that's not something that we ought to be afraid of. And in particular, is not something that we ought to be afraid of here in New Zealand. And the reason for that is we're blessed here by a uniquely international legal community on the one hand, and a very international legal community on the other hand. It is a community that has the best in legal education here, both at Victoria University and elsewhere. lawyers who study abroad frequently, the frequency with which one encounters New Zealand lawyers in international arbitration is very high, and the opportunities for doing so, both because of the country's relative neutrality, English language, common law heritage, are enormous. And the Bilateral Arbitration Treaty, and thinking in particular the New Zealand initiative here, the Bilateral Arbitration Treaty offers real advantages to the New Zealand legal community for being first movers in an area of international commercial dispute resolution that could have real benefits, not just for the ordinary businesses in New Zealand, but also for the legal community in particular. And so with those remarks, I'd be more than happy to take questions from any of you in the audience, from Eric, from others.
Great. Thanks so much. Can you join me in thanking Gary for We do have time for questions. I'd like to note that we are recording, so please state your name and affiliation for the record and your questions, and I'll open it up.
I wondered what your thoughts were on the relative expense of arbitration versus national court dispute resolution, especially in a country like New Zealand. We talk about access to justice or expense. The expense of proceedings plays a big role. Yeah,
no, that's a good question, and one that deserves a careful answer. One of the advantages that businesses historically have seen in arbitration is precisely that of expense, and I've referred to that under the rubric of efficiency. In looking at expense and efficiency, it's important to be mindful of the fact that it's always comparative. All disputes are unsatisfactory. There's no good way of resolving disputes. Arbitration is not a great way to resolve disputes, but it's the least bad way. And the reason that businesses, among other reasons, choose to use arbitration is that they have greater control over the procedure that would otherwise be the case, number one. And number two, arbitral institutions have been very mindful of the need to contain expenses. They have therefore adopted, for particular kinds of disputes, so-called expeditious or fast-track procedures. They need to be careful in doing this because there's always a trade-off between expense on the one hand and due process or opportunity to be heard on the other hand. One doesn't want to make the dispute resolution process so quick and so cheap that the justice it provides is just rough justice or unsatisfactory justice. But nonetheless, arbitral institutions have done, I think, a reasonably good job in tailoring fast-track procedures for categories of disputes where that is both appropriate and what the parties want. For example, in the Singapore International Arbitral Center rules, for disputes under a certain monetary threshold, a sole arbitrator is appointed. There's a time limit in the period in which an award would be made, and there can be limitations, for example, of the arbitral process to being documents only as opposed to having live hearings, which are a substantial form or reason for the expense. I should also say, and this is important, tailoring the terms of individual bilateral arbitration treaties enables one to impose both softer and harder requirements and guidelines that would ensure that the issue of expense is addressed in a meaningful way. In particular, one could include, as I mentioned in the SEAC rules, hard or soft monetary thresholds for particular kinds of claims, sole arbitrators for some disputes, 3 arbitrators for large disputes, time limits, documents only limitations, and the like. And therefore, one of the advantages of arbitration is that it provides the flexibility that enables one to ensure that the amount of procedure that the parties are given is tailored to the size and importance of their dispute. One has to be careful in doing that, not to tread on procedural rights, but it is possible to do it, and I think it would be important to attempt to do that in the terms of a bilateral arbitration treaty. One point that is also important to make just as a general matter is that when one thinks about the expense of proceedings, it's very important to compare apples to apples as opposed to apples to oranges. And when one compares the cost of an arbitration to the cost of a litigation, one needs to look at all of both. And in particular, when one looks at litigation in our current scenario, one needs to look at, in my hypothetical, litigations in both New Zealand courts and Saudi courts, including both jurisdictional, forum selection, and appellate proceedings. Arbitration has little by way of appeal. It has a limited judicial scrutiny, and one therefore needs to be careful in constructing the arbitral process, which is another reason that its expenses, at least in the eyes of many businesses, tends to be limited.
You're talking about bilateral regimes. Are the multilateral regimes equally common, and do they kind of operate in a similar way?
Mm-hmm. That's an excellent question, and it's something that perhaps I should have addressed. There are, starting with the investment context, there are multilateral regimes along the lines of bilateral investment treaties. They're often not identical, although in some cases they're pretty close. There is, for example, the ASEAN Investment Agreement, which provides a similar kind of arbitration mechanism for investment disputes in the ASEAN region. There is the North American Free Trade Agreement between Canada, Mexico, and the United States, which again includes both free trade provisions, but also investment and investment dispute resolution provisions. There's the Energy Charter Treaty, which, although focused on a particular economic sector, energy, contains within it an arbitration provision for investment disputes between a couple dozen countries. So there are definitely multilateral models in the investment context. Exactly the same thing is possible, needless to say, in the international commercial dispute resolution setting as distinguished from the investment setting. One could have, instead of a BAT, a MAT, a multilateral arbitration treaty, and indeed there might be certain benefits to doing that. For example, in a common linguistic area, one can imagine Latin America, or a common economic zone. I've heard talk of a Greater China bilateral arbitration, multilateral arbitration treaty, and one can certainly conceive of it in other areas, common law jurisdictions, Commonwealth jurisdictions, that sort of thing. So I think it's an excellent question, and it is certainly something that the bilateral arbitration treaty would be capable of being expanded into.
Surely it's reassuring to say that employment disputes, consumer disputes are outside of the ambit of the BAT, that is concerned only with commercial matters, but increasingly contractual disputes will have statutory claims, and there's resource management and environmental regulations increasingly involved in commercial transactions. Do you think there's a concern that the BAT might be seen as an attempt to move more and more of those disputes, or have the effect at least of moving more and more of those disputes outside of public forums and into private forums? And would you recommend perhaps a general public policy exception like that in the New York Convention that would serve to allow for an award to not be enforced on public policy grounds?
I would hope that the BAT wouldn't be seen in that way. One never knows quite what reactions a new proposal engenders, but I think any sort of sober, objective reflection on what the BAT does would not push public perceptions in that direction. And I say that for several reasons. First, with respect to environmental regulation or health and safety regulation, the sorts of things that one can understandably raise concerns. Nothing at all in the BAT deals with the authority of regulatory agencies. Regulatory agencies would remain fully empowered to do everything that they presently do to protect the environment, to protect health and safety, to protect other things that are of importance to the public. The proposed BAT includes within it a non-arbitrability exception, as I said previously, insofar as a state considered that even though two private parties are involved in a contractual dispute, that somehow that touched upon public values in such an unacceptable way that it couldn't be arbitrated, the BAT wouldn't apply to those sorts of disputes, just as the New York Convention, which works perfectly well in this country and 149 other countries around the world, works perfectly well. In my own personal view, the scope of that non-arbitrability exception ought to be quite narrow. Most national courts have, in fact, interpreted in that fashion. But if one had a different view, one could either elaborate that view in the Bilateral Arbitration Treaty, or courts would subsequently have the flexibility under the general terms of the non-arbitrability exception to carve out those areas, such as, and I referred to this, bankruptcy or matters related closely to criminal law, and leave those outside the scope of the Bilateral Arbitration Treaty. I do think it's important that one not create, if you will, a Swiss cheese with so many exceptions that the basic product is affected, but I think that ought, given the experience of the New York Convention, to be more than doable.
A clarification about scope. You said regulatory agencies would not be affected by this. So, for example, if a container load of goods is turned back as not meeting some food safety requirement or whatever, it would not apply. What about if the container is accepted by the customer and then found not to comply with some local regulation, possibly genuinely or possibly not genuinely, which often happens? So that's one question of scope. The second one, you referred to companies. Are you saying that individuals or trading trusts would not be able to take advantage of this? Because particularly in exporting services, personal knowledge and skill, that can be quite important.
Yeah, but both of those are good questions. And let me take the second one first. As I've described it, the BAT is focused on corporations, companies, legal entities. It doesn't need to be that way. The Bilateral Arbitration Treaty just as easily and you know, in my own personal view, more desirably, would include entrepreneurs. As drafted, the Bilateral Arbitration Treaty doesn't expressly include natural persons. Out of concerns that I wanted to make sure that this was sort of the purest form of business-to-business dispute, and although there are certainly individuals that engage in business, I didn't want to accidentally sweep in individuals that weren't really entrepreneurs. I think that might be an area where different contracting states would wish to extend the BAT to entrepreneurs, or perhaps create a register of entrepreneurs who could choose to benefit from the BAT's terms, even if without taking affirmative action they wouldn't. I think that's a matter for individual states to consider and approach. I do think that, as you rightly point out, there are important elements commerce that involve individual entrepreneurs, natural persons, instead of legal entities, and if one thinks, as I do, that the BAT is a good thing, then one ought to make that available to them as well. On your first question with respect to scope, let me be clear. Bilateral arbitration treaties, like ordinary international commercial arbitration tribunals, frequently need to address the consequences of regulatory action. If a state denies a permit or takes certain action, if there's a war, tribunals very frequently need to address what impact that has under the parties' contractual relationship. Is it force majeure? Who was allocated the risk of this? Who bears the cost of the container being turned back? The fact that the application of the health rules requires the container to be turned back by regulatory authorities, the fact that the regulators have that authority doesn't in any way affect the arbitral tribunal's authority to work out the contractual consequences of that. And so I think the BAT would be fairly broadly applicable, notwithstanding the fact that, like everything today, businesses act against a fairly heavily regulated backdrop.
You talked about business-to-business disputes. putting arbitrability issues to one side, would your bat or mat apply to commercial disputes between investors and states that are founded in contract, not in a bilateral investment treaty?
The thought would be not. The thought would be that although it is again an issue that could be addressed on a, if I can put it this way, bat by bat or mat by mat basis. It is a good question, because one has, in a sense, an existing dispute resolution regime for investment disputes, and just as one wants, as the BAT does, to make it complement contractual arbitration agreements, one also wants to make sure that it complements existing investment dispute resolution agreements. And the thought would be to leave those investment disputes in the existing regimes, whether they're exit arbitration clauses negotiated contractually or bilateral investment treaty arbitration provisions, leave investment disputes in the investment dispute resolution world. Importantly, though, the BAT would, as I've contemplated it, apply to ordinary commercial disputes, non-investment commercial disputes with state-owned enterprises. And therefore, if, for example, there was a Saudi state-owned company that contracted with a New Zealand investor, its trading, its non-investment disputes, its non-investment commercial disputes would be resolved pursuant to the terms of the BAT. It's important and in particular for those of you who are less, who do less in the international dispute resolution field, it's important to recall that although investment in sort of colloquial parlance sounds broad, in investment law it actually has a quite specific definition and refers in large part to bricks and mortar on the ground in the foreign jurisdiction and disputes arising out of that investment in the foreign jurisdiction. Ordinary, if I can put it that way, ordinary commercial contracts for the sale and delivery of goods or services are not typically covered by the investment regime. They would instead be covered by the bilateral arbitration regime. And in a sense, from my perspective, the fact that we have a specialized regime for the resolution of investment disputes, international investment disputes, argues all the more forcefully for also having a specialized default regime for ordinary commercial disputes. If one works, why not use the same model for the other? And indeed, the arguments that one sometimes hears against investment arbitration are for the most part entirely inapplicable to the bilateral arbitration treaty regime for commercial disputes. It carves out most of the sensitive regulatory areas, the consumer disputes, the employment disputes that one sees giving rise to concern under TPP or other investment regimes.
Thank you. Just firstly, one point about the benefits of such a regime. I mean, Chris Nixon from New Zealand Institute of Economic Research. What we're really quite interested in is bringing down barriers so we can get firms into those markets, and then they can decide what they can do. So the benefits are about integration rather than trade, and that's what we're quite more interested in. Secondly, the question is then it becomes, well, it will be used if people see an advantage in using it. So implementation is extremely important. Have you given any thought about how it might be implemented?
I mean, those are two great questions. On the first, with respect to reducing barriers to trade and integration, I think there's some very important lessons to be learned from other free trade areas. And in particular, one thinks about the European Union on the one hand, the United States on the other. Two sets of states that sought very assiduously and with lots of care at different points in history and from very different perspectives to create an open economic space with a very substantial reduction in trade barriers. Although they adopted very different approaches to many aspects of what they did, one thing both did as a very fundamental aspect of their free trade zones was to provide a solution, an attempted solution, I might say, to the very problem we're talking about. In the European Union, a critical part of the Union was the Brussels Convention and then the Brussels Regulation that allocated jurisdiction between member states and provided for the recognition and enforcement of judgments across borders, precisely because it is those obstacles that are such a problem to cross-border trade. Of course, other things, free movement of goods, free movement of people, tariffs are hugely important, perhaps more important in the sense of what are you going to address first. But fundamentally important to the European enterprise was the Brussels Convention. It isn't perfect. The bad is better. It isn't perfect because it leaves it open for parties that don't really want expert, expeditious, and enforceable judgment to start proceedings in a member state where they will languish for literally decades. The BAT doesn't permit that. The BAT requires you to go into the arbitral process, enables a party that wants speedy, efficient, and expert justice actually to get it, and that's after all what the legal system is meant to do, to allow parties to enforce their legal rights. Exactly the same thing in the United States, from a very different period in history, from a very different perspective and set of legal cultures. Full faith and credit clause and the due process clause allocated jurisdiction between different localities and provided for the cross-border recognition and enforcement of, in that case, state court judgments. The BAT does the same thing. It provides a forum, not one of the member states where one is subject to the vagaries of a particular member state or a particular United States, but instead a neutral arbitral forum that will produce an enforceable judgment. So I think in terms of integration, it's actually very instructive to look at what others who've gone before us have tried to do, what they've thought is important, and what's gone wrong with what they've done, and how we can do a better job. That's the answer to the first question. The answer to the second question, implementation, is to some extent similar in the sense that I think history, we have the benefit of standing on the shoulders of others in a sense. History teaches us that international commercial arbitration has, and the practitioners in that field, has been working really hard to implement properly international commercial arbitration agreements. There are a variety of arbitral institutions around the world that periodically, every few years, revisit their rules, improve them. The UNCITRAL arbitration rules are one example, as I mentioned. Those rules are revised every few years. They're revised on the basis of, literally thousands of international commercial arbitrations conducted every year. Just like when you drive your car, you find out you've got problems with your equipment. So people have found with various commercial arbitration rules. And the good position that we're in is that a lot of those bugs have been worked out. Trust me, there'll be new ones. There'll be new problems. I meant it when I said arbitration isn't a great means of dispute resolution. It's the least bad means of dispute resolution. And the reason that it's least bad is people have devoted a whole lot of thought to how these arbitration rules work. And the BAT would, if you will, inherit all that accumulated knowledge. Now, I also think it's important, though, that there be educational programs, whether here at Vic or elsewhere, making sure that practitioners and arbitrators are aware of what would be a change in the legal regime, make sure that part of the implementation, training, information outreach to folks that support New Zealand Initiative and others, all that takes place. When you drop a new statute onto both the business and the legal community, the sort of bedding in period is very important, and I think that would need to be done. I do think, and I reached this point at the very end of my comments, but I do think this is a real opportunity for the New Zealand international legal community. I think there would be very substantial benefits to an already robust community that exports high-value services from being first mover in this regard. If you think about the New Zealand bar being involved in a substantial number of new international commercial disputes arising under bilateral arbitration treaties, the recognition, the profile, the experience, the know-how that they would gain from that, especially the younger ones in that community, I think it would be a very substantial benefit to that community and the broader New Zealand community.
Just really quickly, what about confidentiality of the proceedings and the existence of the proceedings?
Mm-hmm.
I don't know if you mentioned that.
Yeah, no, that's also a very good question.
Our justice system is open and transparent.
Yeah, and I think that's something that would warrant careful study involving both the business community and also the legal community here. And because there's a tension between two sets of values. One value is here in New Zealand and elsewhere, it's long been thought that commercial disputes are best resolved between the parties, not by press release. That when companies litigate their disputes on the front page of whatever, with the greatest respect to the press, when they litigate their disputes on the front pages of the business section, is not conducive to either an efficient or effective, sensible outcome. And that, at least for business disputes, and other disputes are quite properly treated differently. For business disputes, doing it confidentially as opposed to in public is a good thing. And therefore the default rule in New Zealand and many other countries around the world for international commercial arbitration is that they will be confidential. On the other hand, there is a quite serious argument that, well, if the state is going to provide a default solution, then the default solution ought to be open, the way that the default solution currently, national courts, is for the most part open. Not all countries actually take that view, but a fair number do, and we do here in New Zealand. And so I think there is a reasonably serious argument that these arbitrations, the BAT arbitrations, ought to be open, at least perhaps subject to an opt-out by the parties to the dispute. You can imagine the default rule as between the two parties being they'll be open, but should both parties agree that they will close the door, so to speak, that would be possible. There's also an in-between position, which could be, well, we're going to have the proceedings confidential the way historically they've been, but the award, either unredacted or redacted, will be public, and we will make it public for a couple reasons. One, so that everyone can see that the system is working and have confidence in the system, but then secondly, just like the awards in the 11th century were sometimes circulated and one relied on reputation, those benefits might also be obtained in the 21st century, 10 centuries later, and equally important, one would get the benefits of the thinking and decisions of the tribunals that made these awards. These awards would be reasoned, the way national court judgments are. Sometimes the reasoning would be better, and sometimes it would be worse, but the decisions would be there, contributing to a kind of body of international law between the two contracting states, New Zealand and Saudi Arabia, and providing guidance for businesses in future disputes. Which one of these three options, strict confidentiality, strict transparency, a hybrid, one chooses, I think is fair game for discussion. Different treaty partners, Saudi Arabia, China, the United States, might have different approaches to this, might attach different values, and it's something that I think could be tailored in particular cases.
We've hit time, so we don't have time for more questions, but we can continue things informally over sandwiches and nibbles over there. Thank you so much, Gary. This has been fascinating. I was a little skeptical coming in, saying, well, this is so great, why aren't firms already doing it? But just changing the default conditions seems eminently sensible. I'm hard pressed to see any further buts. So thanks everyone for attending, and thank you, Gary.
Thanks.